Hello and welcome to Cornerstone Commentaries. Today our guest is Lindsey Wakely. She will be discussing campaign activities by state and local officials and whether those activities are permissible under North Carolina law.
Hello, I'm here to talk to you today about how public funds may not be used for partisan campaign purposes. A line is typically drawn between campaign activities and informational activities by state and local officials. Public information efforts that give a fair presentation of the facts are allowed in the context of an election cycle, whether that be an election for public office or an election relating to a referendum or other sort of initiative matter. Much of this law comes down from a key case out of the California Supreme Court in 1976 known as Stanson v. Mott. In that case, the California Supreme Court struck down a $5,000 distribution to support the passage of a referendum by the California Department of Parks and Recreation. Now, ultimately, most of the case law dealing with the issue of campaign activities versus informational activities and whether or not the particular expenditure is improper stems from two different lines of thought. Either that the distribution is improper because it was not explicitly authorized by law, meaning there's nothing in the statutes that gives the agency or government body the authority to use public funds in that matter, or on the broader ground that such expenditures are never actually appropriate use of public funds. Now, the North Carolina Court of Appeals has also adopted this line of reasoning and this line of cases in a 2002 case known as Dollar versus Town of Cary. Now, in the Dollar case, the North Carolina Court of Appeals held that elected officials cannot attempt to influence an election by advertising a particular viewpoint. Now, in 2002, the Cary Town Council made a $200,000 advertising buy to support and advocate its managed growth policies. Now, in general, this would be considered a sort of informational activity. Cary is putting out information of a factual nature about the sort of growth policies that it's currently engaging in. What was a problem in this particular case was the timing and as the court put it, the style, tenor, and timing of the advertising buy. Now, the Cary Town Council election taking place that year, one of the major issues in that election was the growth policies of this current town council. Many of the candidates were opposing those policies, some of those candidates were supporting the policies. By the Cary Town Council's decision to advertise in favor of their own policies during that election, the Court of Appeals determined that that $200,000 expenditure ultimately was a campaign expenditure, indicating the city's support of candidates who would continue to enforce its current policies. In 2010, the North Carolina General Assembly affirmed this viewpoint by the North Carolina Court of Appeals by passing a new law that explicitly prohibited counties, municipalities, and local boards of education from engaging in certain campaign activities. In particular, the law stated that these entities should not use public funds to endorse or oppose a referendum, election, or a particular candidate for elective office. Now, this would cover a situation, as we talked about in the first case of Stanson v. Mott, where you had the California Department of Parks and Recreation actually putting forward a $5,000 contribution towards a referendum campaign. Under this new law by the North Carolina General Assembly, those kind of expenditures are explicitly prohibited. As I said again, though, they only particularly mentioned that using public funds was prohibited. There's nothing in the current law that would restrict, say, a local town council member or a member of a state agency, which these laws don't specifically cover, from giving a viewpoint, saying in any sort of formal way that they are for or against this particular referendum. It's simply a matter of the expenditure of public funds, which tend to be the problem. Thank you very much.